All right, this is in the matter of the people of the state of Michigan versus Jamie Lee Carden, file number 2022-21124 FC. I have David Goldstein appearing on behalf of Jamie Carden. I have Jacqueline Weiss appearing on behalf of the people. Is Mr. Hartung also here on this? And Douglas Hartung appearing on behalf of the people. This is a date and time set for a plea in this matter. I have received an amended information. Mr. Goldstein, have you received that amended information?
Yes, Your Honor.
All right, and how would you like to proceed?
Before we begin, Your Honor, I'd like to ask my client some questions.
Okay, so Ms. Carden, yep, you'll stand there and I'm going to ask you to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay, let's step by the microphone with Mr. Goldstein.
Ms. Carden, did we have more than one conversation prior to today about pleading in these matters?
Yes.
And during those conversations, did I explain to you there were different offers made, and then did I explain to you the latest offer?
Yes.
That included an offer from the people with regard to what the charges would be, and an offer that included what we call a Cobb's agreement with the court regarding your sentence.
Yes.
And did you believe during those conversations that you understood what the offer was?
Yes.
And did you at some point during that the last conversation indicate that you wanted to accept?
Yes.
Now, you did, however, say that part of the reason you wanted to accept was that you didn't have, okay, I'm sorry, prior to that discussion, did I indicate to you that the decision was strictly yours as to whether you took the offer or not?
Yes.
But did I tell you that since I was not being paid, I could not properly mount a good defense for you and would not continue with your attorney if you went to trial?
Yes.
And did I tell you, however, that if you wanted to go to trial, but I didn't want you to decide on that basis, that if you wanted to go to trial, the court would provide you with counsel at no cost to you?
Yes.
Okay. And even after having been that explained to you, did you still indicate to me that you wanted to take the deal?
Yes.
Okay. Has anybody forced you to take the deal?
No.
Has anybody threatened you to take the deal?
No.
Okay. Do you want to proceed and take the deal today?
Yes.
Do you have any reservations at all?
No.
I'm satisfied.
Could you place the agreement on the record then?
Your Honor, my client will tender a plea of no contest to count 1 and to the amended or added count 3 in the one file, the file that ends in FC, and to count 4, which is fleeing and eluding, in the other file. The agreement with the people is that all the sentences that the court imposes would be concurrent. There's a potential for stacking them, but we've agreed that would be concurrent. And the court, after discussing the matter with counsel for both parties, indicated that as a Cobb's agreement, it would not sentence the defendant to more than 12.5 years on the minimum on count 1 of 22-21124 FC.
Let me pause for a moment. Miss Adams?
Yes, Judge.
There is a second file on Carden.
Okay, I will check on that.
What's the file number?
2220792FH.
So Miss Adams, if you could just print off the felony information for me. Or actually, Miss Weiss has one. So I'm sorry, I didn't have that file. I apologize. Okay. So I did not call file number 22-20792FH. And on that file, she's pleading to which count?
Count 4.
Count 4. Okay, and it's no contest as well?
Yes, Your Honor.
Miss Weiss, is that a correct recitation of the plea?
Yes, Your Honor.
All right, so Miss Carden, I've already sworn you in. So you've heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 22-21124 FC to plead no contest to count 1, child abuse first degree, which carries a maximum penalty of up to life or any term of years, but there was a Cobb's agreement that your minimum sentence would be no more than 12.5 years. Is that correct? And it's your, okay, and it's your intention to plead no contest to that count. Okay, so you're kind of soft-spoken. Yep, no, it's fine. And Mr. Goldstein, you can move the microphone a little bit lower for her, because, yeah, and then I need you to speak up so we get a good record, okay? And then on that same file, is it your intention to plead no contest on count 3, assault with intent to do great bodily harm less than murder or by strangulation, which carries a maximum penalty of up to 10 years in prison?
Yes, Your Honor.
Okay. And then on file number 22-20792FH, is it your intention to plead no contest on count 4, police officer fleeing 4th degree, which carries a maximum penalty of up to 2 years in prison and or a $2,000 fine, along with a license suspension not to exceed 5 years? So is it your intention to plead no contest?
Yes, Your Honor.
All right. Now, your attorney thoroughly asked you about this plea, so you've had ample opportunity to speak with him.
Yes, Your Honor.
And you understand if you didn't want to enter a plea and you wanted to continue to trial, the court would appoint counsel to represent you.
Yes, Your Honor.
But you wish to continue with the plea,
Yes, Your Honor.
and you are satisfied with Mr. Goldstein as your attorney and the advice that he's given you.
Yes, Your Honor.
Okay. Let's see. So other than the plea agreement and the Cobb's agreement regarding count 1 of file number 22-21124FC, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Goldstein?
That's correct, Your Honor.
Mr. Hartung?
That's correct, Your Honor.
Ms. Weiss?
That's correct.
Okay. And that correct as far as you're aware, Ms. Carter?
Yes, Your Honor.
If a guilty or if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
Oh, yeah.
All right. So, Ms. Cardin, on file number 22-20792FH, your options are not guilty or no contest, okay? How do you wish to plead to the charge that on or about March 16th of 2022 in the village of Blissfield in the county of Lenawee that you did commit the offense of police officer fleeing 4th degree?
Yes, Your Honor.
No
No contest.
Okay. And then on file number 22-21124FC, how do you wish to plead to the charge that on or about January 1 of 2016 in the city of Morenci in the county of Lenawee that you did commit the offense of child abuse 1st degree?
Your Honor, before she responds to that, there is going to have to be a change to the information. When it was retyped, they put January 1st, 2016. The original information contained a time period starting January 1st of 2016 and ending June 5th of 2019. Ms. Weiss is going to move to amend.
Ms. Weiss, you amend that?
I do move to amend that, Your Honor.
Okay, and you'll get a copy of that to us today.
Yes, Your Honor.
Okay, all right. So, Ms. Cardin, how do you wish to plead to the charge that during the time period of January 1 of 2016 through June 5th of 2019 in the city of Morenci in the county of Lenawee that you did commit the offense of child abuse 1st degree? And on that same file, during the time period of January 1 of 2016 through June 5 of 2019, in the city of Morenci in the county of Lenawee, how do you wish to plead to the charge that you did commit the crime of assault with intent to do great bodily harm less than murder or by strangulation?
No contest.
All right. Has anyone made any threats or promises to you to induce you to plead no contest to any of these charges other than what was placed on the record? You understand that if I accept these pleas, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? Mr. Goldstein,
No, Your Honor.
Mr. Hartung.
I should probably place on the record that it was alluded to in Mr. Goldstein's reading to Ms. Carvey earlier, but this will be a non-consecutive sentence. You did not outline that during your reading of the rights. And the other thing we probably should put on the record is the basis for the contest.
It would be for civil liability, obviously.
Okay, so civil liability and it's non-consecutive,
That's correct.
so it'd be a concurrent sentence?
That's correct.
Okay. Do you know what that means? All right, Mr. Goldstein.
No, okay. You had two different files, okay? There is a potential that you could get a sentence on one, and then after you did that sentence, you would start your second sentence. That's called consecutive. But the prosecutor has agreed that if you receive a sentence on all of these charges, they're all going to run at the same time. Okay.
Do you understand?
Yes, Your Honor.
Okay. So Ms. Weiss?
Your Honor, I
Well, I think I was bouncing around, so I said, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead no contest? He added that.
No, Your Honor, not to my knowledge.
Has your attorney, I know that there's a COBS agreement to no more than 12 and a half years in prison on the one count, but other than that, has your attorney promised you any particular sentence or estimated what your sentence will be? Is it your own choice to plead no contest?
Yes, Your Honor.
All right, who will be placing the factual basis on the record?
Your Honor, I will, but I believe Mr. Goldstein and I would stipulate to using the preliminary exam transcript as well as the trauma assessment report that I will get to the court. However, I have summed it up for the court to make its findings for today.
And can you please use initials?
Yes, absolutely.
Thank you.
I would indicate before she does that, she and I did meet prior to court today, and I've agreed on that because we'll take the court. This is not one of the kind of cases where you go to one paragraph and find the elements of the crime, so.
One last thing would be that the court indicated in this card that the sentence would not exceed 12 and a half years. 12 and a half years on the minimum.
On the minimum, I did say that earlier. So you understand there's a minimum and a tail. So any term of years, but your minimum sentence would be 12 and a half years. Do you understand that? Okay.
Would be no more than 12 and a half years.
No more than 12 and a half. No more than 12 and a half. Okay. So Ms. Weiss, which file are you going to start with?
The FC file.
Okay. And I do have copies, so originals are probably filed across the hall and the amended informations.
I would assume so. We got that done this morning, so.
Okay. All right, so you're going to start on the FC file. So on 22-21124 FC. Ms. Weiss.
Okay, Jamie Carden was the mother of 6 children. TC, date of birth, 6/22/2004.
Don't put date.
For ages.
We can say the age, but we're not allowed to put date of birth.
Yeah.
Well,
If you could just say at that time she was,
At the time of January 2016 through June 2019, for the date of the information, all these children were minor children.
under the age
I would
of,
agree with that, Your Honor.
Correct.
under the age of 17?
Yes.
Yes,
Okay.
yes. We have TIC, DEC, TRC, DAC, TEC, and DAMC. And to clarify, some of these incidents happened outside of the city of Morenci, although some did happen. So for the purposes of this, we would just indicate that between January 1st, 2016 and June 5th, 2019 in Lenawee County, Michigan, all these instances occurred. Based on testimony from both Chris Carden and Muriel Polaskinski, beginning in 2013, Chris and at least 3 different CPS workers discussed with Jamie that Sam Compton was a convicted sex offender and not to have her children around him. Jamie abused pills, cocaine, and methamphetamine. During that time frame, Jamie had care and custody over her children. Beginning in January of 2016, Jamie would regularly drop off her children to Sam Compton. TC testified that Sam would take her to his bedroom, take his clothes off, take her clothes off, rub her on her inner thigh, both inside and outside her vagina. Sam did this to her multiple times. TC told Jamie Sam was doing this to her, and Jamie didn't listen or believe TC. Every time Sam would watch the children, Sam would pay Jamie. After TC told Jamie Sam was doing this, Jamie continued to drop the children off to Sam. TC testified that Ernie Black was one of Jamie's friends that would frequent the
Could you
house.
slow down your reading? And so when you read really fast. I'm trying to take notes.
I'm
What
sorry,
was the net? Ernie Black?
Ernie Black. TC testified that Ernie Black was one of Jamie's friends that would frequent the house in Morenci. The first time TC met Ernie, TC was 5 or 6 years old. Ernie showed TC and DAC a video of naked people on a bed doing stuff to each other. Ernie told the girls that if they did that with him, he would give them candy. The girls declined his offer. Ernie first went to DC's top bunk and DC left the room. Ernie then went to TC on the bottom bunk of their beds and was rubbing on her like Sam would on her thighs and vagina. TC told Jamie about this. Ernie came over again after TC told Jamie. This time TC was in the living room. Ernie undressed himself and TC. He got on TC and was rubbing his penis in between her thighs. TC testified that his penis went inside the lips of her vagina, but not all the way inside of her. TC told Jamie about this incident. Jamie did not believe her. Jamie continued to allow Ernie to come to the home, and Ernie kept doing these things to TC. Muriel Kolosinski, the CPS supervisor, testified that Jamie admitted to her that she allowed Sam Compton to watch the children for her unsupervised during this time period because of her substance abuse disorder and because he was giving her money. Jamie had been notified by previous CPS workers that if she continued to have her children around Sam and something happened to them, she could be held criminally responsible. Sam told Kolinsky that he had been with the Cardin children up until July of 2019 and that he regularly babysat them. He gave Jamie a car and money, which Jamie confirmed. There was a trauma assessment form that was completed from the Southwest Michigan Children's Trauma Assessment Center dated February 28, 2020, signed by Samantha Ferris, LMSW, Jim Henry, PhD, and Mark Sloan, DO. Page 17, under the comment section. TC meets full criteria for post-traumatic stress disorder, and her sexual distress scores at the ceiling, the highest possible level, which is very concerning and indicates the profound impact her experiences of sexual abuse have had and continue to have. Page 18, the second to last paragraph. TC displays reactive, aggressive, and oppositional behaviors, which must be recognized as trauma symptoms and not attributed to a lack of respect or willful defiance. The last paragraph. While TC is no longer in imminent danger, her brain cannot register safety and continues to fire messages of survival. Trauma has injured her brain. Page 21 is the diagnosis, post-traumatic stress disorder, chronic type. Based on all the above facts, Jamie Cardin did knowingly cause serious mental harm to TC by unlawfully conspiring with Ernie Black and or Sam Compton to engage in sexual penetration of TC.
Is it 1, 2, or more incidents of sexual penetration?
Multiple incidents of sexual penetration.
More than 3?
Yes. By both Sam Compton and Ernie Black.
Any additions to that, Mr. Goldstein?
No, Your Honor.
And is that to satisfy both count 1 and count 3?
Yes, Your Honor.
Yes, Your Honor.
Based on the facts placed on the record and from the information contained in the police report, preliminary exam transcript, as well as the 2020 trauma assessment, the court finds beyond a reasonable doubt that during the time period of January 1 of 2016 through June 5 of 2019, in the city of Morenci and the county of Lenawee that the defendant did commit the offense of child abuse first degree by knowingly and intentionally allowing serious physical and mental harm to a child and causing it by allowing two registered sex offenders, Ernie Black and Samuel Compton, to babysit unsupervised the minor children, all under the age of 17. The children did approach their mother and report that the abuse was happening, and the mother failed to remove the children from the situation or report it. In exchange for him being allowed to babysit her children, she received a vehicle as well as cash. So I think that satisfies child abuse first degree. On the count 3, assault with intent to do great bodily harm less than murder or strangulation. Ms. Cardin received multiple reports that her children, specifically TC, was being sexually assaulted by both Ernie Black and Samuel Compton, with at least a minimum of 3 sexual penetrations by Samuel Compton and 3 sexual penetrations by Ernie Black, and continued to allow the children to be sexually assaulted by those individuals. And specifically, TC has been diagnosed with PTSD, along with some reactive behaviors and oppositional defiance disorder. And the doctor stated that he believed there was the actual damage to her brain from the PTSD and abuse. Anything I need to add to that for count 3?
No, Your Honor.
No, Your Honor.
No, Your Honor.
And therefore, the court finds that the defendant did commit the offense of child abuse first degree, as well as assault with intent to do great bodily harm less than murder or by strangulation, and does accept the no contest pleas for both of those counts. So moving on to file number 22-20792FH. Who's gonna?
I can do that if I can approach and grab the information from you. Yeah, I'll grab one of those. It's okay. Your Honor, on or about March 16th, 2022, in the village of Blissfield, County of Lenawee, State of Michigan, Jamie Lee Cardin was operating a Ford Explorer on Main Street. Officers in a fully marked patrol vehicle from the village of Blissfield did activate their emergency lights in an attempt to stop Ms. Cardin. Officer Anton, who was in full uniform and identified as a police officer, who was acting in the performance of his duties, did indicate to Ms. Cardin that he was attempting to pull her over. At that time, she attempted to flee Officer Anton and struck his vehicle in his attempt to flee. In her attempt to flee, I apologize.
Was he in a fully marked police car with the lights?
Yes. I apologize, I thought I said that, I'm sorry, but yes. Oh,
Was there a speed limit requirement?
no, not on this one.
Not on this one, Your Honor.
Can I have the felony information?
Yes.
Okay. Anything to add to that, Mr. Goldstein?
No, Your Honor.
Based on the facts placed on the record and from the information contained in the police report, the court finds beyond a reasonable doubt that on or about March 16 of 2022 in the village of Blissfield in the county of Lenawee, that Ms. Cardin was operating a motor vehicle, I believe it was a Ford Explorer, in the village of Blissfield, and Officer Anton, a police officer in a fully marked uniform and a fully marked motor vehicle, attempted to pull her over, and she failed to pull over and attempted to flee and or elude the police officer and ended up striking the police officer's vehicle. Is that correct?
Yes, ma'am.
And the court therefore finds that the defendant did commit the offense of police officer fleeing fourth degree and accepts the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Mr. Goldstein,
Yes, Your Honor.
Mr. Hartung,
It has, Your Honor.
Ms. Weiss?
Yes, Your Honor.
I do find the plea has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. There has been a COBS agreement for one of the counts, as well as the added terms that the sentence would be concurrent. And I'm going to refer this matter to the probation department for a pre-sentence investigation. Are you currently on parole or probation?
Yeah.
Okay. Mr. Goldstein, I can do January 5 at 8:15.
That would work, Your Honor. That's Friday, right?
Yes.
Yeah, that's right.
Yes, ma'am.
Right, I will set this for sentencing on January 5 at 8:15 in the morning.
I would indicate, Your Honor, that we are scheduled for a jury trial on Wednesday in front of you, so yeah, I'll be here probably one way or the other.
On January 3rd.
I have Zachary Rose. Did we move that? Did we
No,
move that?
it's still going.
So, yeah, January 3rd.
So Miss Adams, could I set this
And I
for
hope it's-
January?
Go ahead.
January. Miss Hennigan, you're not muted. I don't, oh, maybe you are. Miss Adams, can I set this for January 3rd or January?
That's a Wednesday. I don't mind putting it on for Friday with your.
I can do it in the afternoon if you're here for the trial.
Okay, that's fine.
Okay.
Judge, we were
Can I
doing
set it?
January 5th, if that's what you were asking.
Say it again.
We were doing January 5th on the other cases.
Right, but Mr. Goldstein has a jury trial in front of me on January 3rd.
Okay.
So could we do 1:30 on January 3rd?
I do not see him on January 3rd.
When is Zach Rosenberg set?
Got down for the 3rd.
Hold on. Miss Adams, when is Zachary Rosenberg set for trial?
Checking, Judge.
Maybe you weren't going to trial that day. Would have been a surprise. Miss McGrain, I'm going to send you a chat.
I apologize, Judge. That does say January 3rd.
Okay. Okay. So can I set this for sentencing January 3rd at 1:30?
Sure.
Okay, so I'll set sentencing for January 3rd at 1:30. Mr. Goldstein, it can be in person. So Ms. Carden, you do have a right to be present in person, or you can appear via Zoom. I leave it to both of you.
Since I'm going to be here anyway, I think we would prefer that she be here.
Okay. If by chance, Mr. Rosenberg pleads out or something, we can make up the arrangements. All right. So Ms. Carden, someone from the Michigan Department of Corrections is going to meet with you and they're going to prepare a pre-sentence report on both of these files. When you meet with them, make sure you're honest with them about your background and also the events that, well, you pled no contest, so you don't have to make a statement about the events that occurred, but be truthful with them about your background. They'll prepare a report. We'll provide that to Mr. Goldstein. He'll review it with you. We'll provide a copy to the prosecutor and they can review that with any of the victims in this case. And then we'll be back at that time for sentencing. Anything else we need to add?
No.
No, Your Honor.
All right, bonds
Thank
continue.
you.
Thank you. Miss Adams, can you check the clerk's office to make sure we have original information over there? I don't know.
We do not, Judge. If you could hang
All right,
on.
Ms. Weiss, we're gonna need original amended information, so we don't have them anywhere.
Oh, okay, yes, I will do that.
They could be on their way somewhere.
Okay.
Judge, did you need to speak with me? You said you're gonna send me a chat.
I'm sending you a chat right now. Hold on. All right, so Ms. Hennigan, I don't know that I'm gonna be able to do this today because my jury's getting ready to come back and I've got to do closing arguments and jury instructions. So. Okay. So Ms. Hennigan, I can do a couple things. I can move this till 3:30 today.
Okay. I'm available at 3:30, Your Honor, but my client's on Zoom in Florida. I'm not sure of his availability at that time.
Well, we'll check. I don't usually worry about our clients' availability, just the attorneys. I can't schedule for everybody.
I understand.
Client. All right, sir, can I have your name for the record, please?
Brandon Carey Schaus.
All right, so Mr. Schaus, I am in the midst of a criminal jury trial. My jury is about ready to come back in. I need to do closing arguments and jury instructions. Are you available to log back in like at 3:15 Michigan time?
I can try. I'm at work right now. Yeah, I can
What
do
time? What time is it in Florida?
it. It's same time, 1:45.
Okay. Would you rather me set this for another day?
No, I'll log back in. I mean, I don't, I just rather get it over.
Okay, so why don't, how about 3:30 log back in, Ms. Hennigan and Mr. Schaus, okay?
All right,
Okay.
thank you.
All right, thank you. Okay, so I'm gonna step off the bench for just a moment and then, I need to get you guys to sign the. Oh, he's not. Oh, there's this.
I think we did that.
I know, but did you, I gotta double check it. We're gonna put it in sleeve. Okay, so verdict form. Okay, so both parties initial verdict form. All right, we're gonna take a quick recess. Second. Are you here? Is there an extradition? I don't know what I'm gonna get to that. It might be an hour and a half. Thank you. You're welcome.
Yeah. I didn't even get to say. Yeah, I know, it's just, and it's just so, you're just. everybody's so humble and nice. Yeah, try. Don't give up. Yeah. So sorry, I apologize. Didn't get a chance. Like, oh, shit. I didn't catch it, so. Go downstairs. No problem. Good. No. I haven't.
grab them for you? Out of the.
I never had those kind.
It's good.
Is it regular? coffee?
Yeah.
Is it?
It's just regular. I'll tell you,
Yeah.
I'll make you one.
Okay, thank you.
I'll do it. Okay.
I need both of them. Just need the attorneys to start.
Oh, I'm here. Sorry.
I just don't.
I just saw him going, he's going to his office. He was just going toward the stairs. Oh, Alex, hey, that.
Yeah, I'm ready to start the trial, so just let me know when.
Right, guys, I can't.
No, I think I saw him going that way. I was hoping he wasn't going downstairs. Oh, there it is. Oh, good. Oh.
Okay, so we are, got everybody we need. All right, so this is, we're back on the record in the matter of the state of Michigan versus Alan David Crystal. Are the people ready to proceed? for closing argument?
I would like to use the screen for.
So all you have to do is plug it in and unplug it.